The phones were not supposed to be trusted. According to federal prosecutors in Boston, members of an alleged insider trading network used burner phones, encrypted applications, coded language, and in-person meetings, where electronic devices were turned off or placed away from the conversation. The subject was not drugs, weapons, or state secrets. It was corporate deal information, the quiet, market-moving intelligence created inside elite law firms before mergers and acquisitions became public. In the government's telling, the product was secrecy. The supply chain began with confidential files inside major law firms. The distributors were allegedly lawyers, insiders, middlemen, and traders. The commodity was material non-public information, or MNPI. The payoff was allegedly tens of millions of dollars in illicit trading profits over roughly a decade. On May 6, 2026, federal prosecutors in Boston unsealed charges against 30 defendants, while the Securities and Exchange Commission filed a parallel civil case against 21 individuals. The defendants included corporate attorneys and financial professionals. Prosecutors alleged that the network stole and used confidential information on nearly 30 merger and acquisition deals from some of the nation's leading law firms, including one headquartered in Massachusetts. This was not only a story about trades, it was a story about method. According to the indictment, the alleged scheme treated M&A information like contraband, extracted from professional systems, passed through layers, disguised through code, traded through accounts that allegedly obscured the real beneficiaries, and moved through cash, intermediaries, shell companies, and foreign locations, including Panama and Switzerland. The allegation was simple in legal form, but vast in architecture. A network built around access, silence, and distribution. In modern markets, the most valuable information is often not a number on a balance sheet. It is timing. A pending acquisition can change the value of a public company overnight. Before an acquisition is announced, only a narrow circle is supposed to know: executives, bankers, lawyers, advisors, and select internal teams. When that information is material and not public, trading on it in breach of a fiduciary duty or relationship of trust and confidence can constitute illegal insider trading. Violations can also include tipping the information, trading by a person who receives the tip, and trading by those who misappropriate the information. That is why M&A law firms are information vaults. A corporate law firm working on a merger may hold draft agreements, diligence materials, client communications, internal deal names, board documents, antitrust analyses, and transaction calendars. Those documents can reveal not only that a deal exists, but whether it is alive, delayed, threatened, or close to announcement. In the Boston case, prosecutors alleged that confidential information was taken from major law firms advising on mergers and acquisitions. The government's theory depends on that trust structure. Lawyers and professionals do not merely receive sensitive information, they receive it because clients, firms, and markets assume the information will be protected. U.S. Attorney Leah B. Foley said the alleged trading exploited the special access and ethical duties that come with a law license, and that markets and professional firms should be free from fraud and breaches of duty. According to the SEC, the alleged civil scheme involved information misappropriated from multiple global law firms and resulted in millions of dollars in alleged illicit profits. The SEC alleged that Nicolo Nuravchin, a Los Angeles-based mergers and acquisitions attorney, orchestrated a global scheme with Robert Yadgaroff of Long Beach, New York, and that Nuravchin allegedly misappropriated MNPI from firm clients involving more than 12 pending corporate transactions. The DOJ described a broader criminal case: 30 defendants, nearly 30 M&A deals, a decade-long alleged scheme, and tens of millions of dollars in alleged illicit profits. The distinction matters. In the SEC's civil case, the regulator sought injunctive relief, disgorgement with prejudgment interest, and civil penalties. In the DOJ's criminal case, prosecutors brought securities fraud, conspiracy, money laundering, obstruction, false statement, and related charges across multiple indictments and related cases. But the center of the story is the mechanism. The alleged network was not described as a single trader with one tip. It was described as a distribution system. According to prosecutors, Nicolo Nurafcan, while working as a licensed corporate attorney at several large law firms, allegedly accessed internal law firm computer networks to view confidential documents about pending acquisitions, including deals he did not work on. Prosecutors allege that he and others then provided MNPI to other participants in exchange for kickbacks. The SEC alleged that Nurafcan and Yadgarov tipped information to other participants who agreed to kick back part of their trading profits, and that some recipients tipped others who traded. The SEC also alleged that Nurafcan and Yadgarov recruited another corporate lawyer who misappropriated MNPI about additional deals and tipped that information back to them. That structure is important. Source, broker, trader, tippee, kickback. The DOJ alleged that Nurafcan and Yadgarov recruited attorneys and insiders as sources of inside information. In exchange for MNPI, prosecutors alleged they paid sources kickbacks of up to hundreds of thousands of dollars in cash. Then came the insulation layer. According to the DOJ, middlemen allegedly provided MNPI to other traders and tippies to obscure the connection between the original sources and the people placing trades. Traders allegedly executed trades either for themselves or on behalf of others, in exchange for agreements to kick back proceeds up the chain. This is the method, not one leak, but a hub-and-spoke market for secrets. The alleged source did not need to place every trade. The alleged middleman did not need to know every original document. The alleged trader did not need to sit inside the law firm. Each layer reduced visibility into the layer above it. Each layer allegedly moved the information one step farther from the professional duty that had been breached. Prosecutors allege that overseas traders in California, Florida, New Jersey, New York, and other locations traded while in possession of MNPI ahead of nearly 30 M&A deals involving public companies on national and foreign securities exchanges. That scale created another problem: communication. According to the DOJ, the alleged conspirators tried to avoid detection by using burner phones, encrypted applications, coded language, including code about flights, and face-to-face meetings where devices were turned off or moved away. The point of the code was not sophistication for its own sake. It was deniability. The government highlighted one alleged example involving iRobot. On or about June 7, 2022, prosecutors alleged that Nicolo Nurafcan, while on a leave of absence from a law firm where he worked, viewed confidential materials in the firm's document management system about a potential acquisition of iRobot, the Roomba maker later targeted by Amazon, a deal he allegedly did not work on. On or about June 16, 2022, prosecutors alleged that Simon Fensterzaub purchased iRobot securities while in possession of MNPI. The DOJ also alleged that from about June 16, 2022, through about July 8, 2022, Silverstein and Simon Fensterzaub exchanged coded messages before more explicit discussion of the deal. In the messages quoted by prosecutors, the pending acquisition was allegedly referred to as a rabbi, and the timing of the public announcement was discussed as though it were a scheduled surgery. That alleged exchange captured the logic of the network. A merger became a patient. Deal status became a medical update. A trading decision became a question about whether to stay in or get out. The scheme allegedly needed secrecy because the information was valuable only while it remained hidden from the market. Once an acquisition became public, the informational edge disappeared. The alleged machine began to break where secret networks usually break, at the seams between people. By May 2026, prosecutors had assembled one of the largest U.S. insider trading cases in years, according to Reuters. Reuters reported that some defendants had pleaded guilty in sealed proceedings dating back to 2024 and that some were cooperating with the government. This point has to be handled carefully. Some defendants have pleaded guilty and are cooperating. That does not establish the guilt of defendants who have not pleaded guilty, and it does not turn allegations against other defendants into proven facts. The DOJ's public release states that the details in the charging documents are allegations, and that the defendants are presumed innocent unless and until proven guilty beyond a reasonable doubt in a court of law. On May 6, 2026, the operation moved into public view. Federal prosecutors in Boston unsealed charges against 30 defendants. the SEC announced a parallel civil enforcement action against 21 individuals. 19 defendants were arrested that day and were expected to appear in federal courts in Los Angeles, Fort Lauderdale, New York, and other locations. 2 defendants located in Russia and Israel were considered fugitives. The structure of the criminal case was split across multiple charging tracks. The first indictment charged 16 defendants with 2 counts of conspiracy to commit securities fraud, 2 counts of securities fraud, and 1 count of money laundering conspiracy. That indictment also charged Nicolo Nurafshan with obstruction of justice and charged Mark Fensterzaub, David Moradi, and Joseph Suskin with making false statements to law enforcement. A second indictment charged 5 defendants with 2 counts of conspiracy to commit securities fraud, 2 counts of securities fraud, and 1 count of money laundering conspiracy. In that second indictment, prosecutors also brought obstruction, false statement, and false declaration allegations against specific defendants. Charges against 9 other defendants for securities fraud conspiracy were also unsealed, and the government said the investigation was ongoing. The SEC's civil complaint charged defendants with violating anti-fraud provisions of the federal securities laws and sought injunctions, disgorgement with prejudgment interest, and civil penalties. The SEC also thanked the U.S. Attorney's Office for the District of Massachusetts, the FBI, FINRA, and regulators in Denmark, the United Kingdom, Cyprus, Mauritius, and Switzerland for assistance. The alleged network had been global. The response was also cross-border. Once the case was unsealed, the alleged machinery of secrecy became the evidence narrative. The DOJ described alleged trading through brokerage accounts in the names of shell companies and other corporate entities. Prosecutors alleged that conspirators enlisted others to trade on behalf of co-conspirators, traded in other people's brokerage accounts, and used foreign brokerage accounts, all to try to evade detection by U.S. securities regulators and law enforcement. The money trail allegedly moved through another layer. Prosecutors alleged that proceeds and kickback payments were transferred in cash and through intermediaries and shell companies in locations including Panama and Switzerland. At times, those payments were allegedly disguised as loans or business transactions. That alleged laundering method mattered because the crime, as charged, was not only about buying before an announcement. It was about turning information into cash and then allegedly making that cash look disconnected from the original leak. The alleged concealment system had 4 components. First, communications, burner phones, encrypted apps, coded language, and device-free meetings. Second, accounts, shell company accounts, third-party accounts, and foreign brokerage accounts. Third, routing. Middlemen who allegedly passed MNPI down the chain to obscure the link between sources and traders. Fourth, money movement. Cash, intermediaries, shell companies, Panama, Switzerland, and payments allegedly disguised as loans or business transactions. Together, those methods formed the alleged architecture of the network. But the same architecture also created exposure. Every handoff created a communication. Every trade created a record. Every kickback created a payment trail. Every coded message created context that investigators could later compare against market events. The stakes were severe. The DOJ said the charge of conspiracy to commit Title 18 securities fraud carries a potential sentence of up to 25 years in prison, while conspiracy to commit Title 15 securities fraud carries a potential sentence of up to 5 years. The DOJ also said money laundering conspiracy carries a potential sentence of up to 20 years. Sentences, if any, are imposed by a federal district court judge under the relevant statutes and U.S. sentencing guidelines. The alleged profits were described as tens of millions of dollars. The alleged source material involved nearly 30 M&A deals. The public charging event involved 30 defendants, 21 SEC civil defendants, 19 arrests, and 2 fugitives located abroad. A system built to hide distance between people was now being mapped by the government as a chain. The central lesson is not that insider trading requires brilliance. It is that insider trading in a network requires trust among people whose incentives eventually diverge. A single insider trading event can be hard to detect if it is small, isolated, and not repeated. But the Boston allegations describe something different: repeated access, repeated tipping, repeated trading, repeated kickbacks, and repeated attempts to hide the origin of information across nearly 30 M&A deals. The more participants a network adds, the more operational capacity it gains. More sources mean more deals. More middlemen mean more distribution. More traders mean more accounts. But each added person also becomes a potential failure point. That is the paradox of the alleged network. Scale creates profit potential. Scale also creates evidence. The SEC's press release stated that its market abuse unit brought the complaint, and the SEC noted assistance from FINRA and multiple foreign regulators. That matters because modern insider trading enforcement is not limited to one suspicious trade on one exchange. It can involve trading patterns, brokerage records, communications, account ownership, cross-border regulator coordination, and comparisons between market activity and corporate events. The alleged use of shell companies and foreign accounts suggests that the participants understood the detection risk. The alleged use of burner phones, encrypted applications, and coded language suggests that communication itself was treated as evidence risk. The alleged use of cash, intermediaries, and disguised payments suggests that the profit trail was treated as exposure. But the core breach was professional. The government's allegation was not merely that people traded before announcements. It was that attorneys and insiders allegedly accessed confidential law firm materials, including matters some allegedly did not work on, and then converted client information into trading intelligence. In that sense, the case is about more than market fairness. It is about the architecture of trust behind public markets. Before a merger is announced, the market depends on controlled silence. The client depends on the law firm. The law firm depends on internal access controls and professional ethics. Investors depend on the assumption that price-sensitive information is not being sold through private networks before disclosure. The Boston case, as alleged, shows how fragile that structure becomes when private access becomes a product. A law firm database becomes a target. A pending acquisition becomes inventory. A middleman becomes a firewall. A shell company becomes camouflage. A coded message becomes a trading signal. A foreign account becomes an escape route. And then the same system reverses. The database access becomes a log. The coded message becomes context. The shell company becomes a link. The foreign transfer becomes a trail. The network becomes a map. That is why the method matters. Not because it was flawless, because it reveals the business model of alleged insider trading at scale. Steal the signal, distance the source, fragment the trade, disguise the money, and hope the market moves before anyone can connect the pieces. According to prosecutors, the pieces were eventually connected. The charges remain allegations. The criminal defendants are presumed innocent unless and until proven guilty beyond a reasonable doubt. Some defendants have pleaded guilty and are cooperating, but that fact does not determine the guilt of any defendant contesting the charges. The lesson is not that markets are perfectly clean. It is that secrecy has a cost, and networks multiply that cost with every person added to the chain. This video is for educational and informational purposes only. All information is sourced from publicly available documents, regulatory filings, and credentialed news organizations. The defendants have been charged. The charges are allegations, and all defendants are presumed innocent unless and until proven guilty. Source links are available in the description.